Now, the major thing that right now they're putting people in prison for is called child pornography. Now, of course, you know what that is. It's pornography involving children, right? Wrong! All right, in order to be child pornography, it doesn't have to involve a child in any way. It doesn't have to be pornography. And it doesn't actually have to be even sexual or sexually suggestive in any way. It can be practically anything, including what you have on your computer right now. I estimate that every collector of Hollywood videos has probably 20,000 images or thereabouts, which could land them into federal prison under the law as applied to me. This should scare you. But maybe it scares you so much you won't believe it, like all Americans. Anyway, if you want to read about this and you're one of those evil un-American readers, I suggest going to oncefallen.org and looking for a document called Site Crime. And also give him money because he deserves it. Also give Harvey money. Buy his books or give money to his organization, thefire.com. Don't give any money to the ACLU. They are worse than useless. But FIRE, in a limited sense, does the things that the ACLU used to do and should be doing and does not do anymore. So I don't have a copy of Site Crime with me, and I don't even remember exactly what was on it, but I've done a lot of research of my own. So I'll tell you some examples of people accused and sometimes convicted of child pornography. First, there was a 17-year-old boy who took a picture of his own genitalia. Bam, child pornography. Production, really serious. Life destroyed. There was a 17-year-old couple, legally married in their state, took pictures of each other on their wedding night. Bam, child pornography, convicted, 2 lives destroyed. Is this of any interest to any of you? All right, let's say 3. There was a guy who was developing or printing some photos at Walmart. The Walmart employee thought he saw something, reported it to the police. They came to his home, guns drawn, pointed the guns at the man's wife and his children. Fortunately, he was off at his hunting lodge and only heard about this later. Also, fortunately, he had a birth certificate and he had a passport proving the woman in the picture was 35 years of age. Now, how many pictures do you have birth certificates related to the person in the picture? So he got up. Yay, America's new perfect. Justice for all. Then he sued the cops. His suit was dismissed under qualified immunity, which means that the cops could not possibly have known that a 35-year-old was not a child. Fortunately, he appealed. 2 out of 3 of the judges said no, the cops didn't get qualified immunity. This almost never happens, but it happened this time. So America is new perfect again. Justice for all. All right, there was another guy who was arrested and actually put on trial for having a video with the well-known porn star Lupe Fuentes on it. Now, Lupe Fuentes is a small person. They got a couple of physicians to testify that she must have been 16 years old. His public defender scraped up the money to fly Lupe Fuentes from Venezuela to the trial, and so he wasn't convicted. America is new perfect. Justice was served. Now, just think, how often does an overworked, underpaid public defender go to that extent? All right? And also think about this. Sometimes the U.S.-Venezuelan relations, whatever they say, are not so good, and you couldn't just hop on a plane with a passport and get to another country. All right? So now I'm going to go into some things that I have actual personal knowledge of because I met these guys. One guy I'll call Varian. All right? A 15-year-old boy was staying with him at the permission of the 15-year-old boy's mother, who the relationship was abusive, and she didn't want the boy to be abused. So the boy took a picture of his own penis and stored it on Varian's computer. When Varian went to Ohio, he brought the computer along. Immediately, interstate transportation of child pornography. The prosecutor wanted 15 years. The judge gave him 29. Now, while he was in Allenwood prison, he was under threat because he was such a horrible child pornographer, and they threatened his life. He got so that he even drew marks where his carotid arteries would be, just as a kind of existential protest. So what they did is they put him in protective custody. Now, when he was there, the guards changed out his cellmate until they found one from a gang who would rape him repeatedly. There's no question but that this was intentional, because one of the guards shouted out loud enough so that the other prisoners could hear through the ventilation system, "Hey, Varian," although he used his real name, "is he too much for you?" Absolutely no question about that. Now, I helped this guy write his 2241. In fact, I pretty much wrote it for him. So I have seen all his papers, all the documentation. I know this. And so what I did is I helped him to get in touch with an organization that I had been in touch with, very good organization called Just Detention International. Give them money too, okay? They're very good. They talk about prison rape. They fight it. And they're very unpopular because Americans believe prisoners deserve to be raped, especially horrible, horrible sex offenders, like a guy who transported a computer. Now, I helped him write his story for them. I don't know what they did with it, but they're a great organization. Leland Aquino is a fabulous person. And so eventually the plague rolls around, and the warden decides that he's going to ship all of us, actually, to other prisons. In my case, illegally, although I managed to, I wrote 50 letters, and only Rabbi Spritzer of Reaching Out helped me. He called the warden and got him to stop. It was illegal because I was still under the protection of having filed habeas corpus with the Supreme Court, and also I had filed my 2241 by then. And you're not supposed to ship somebody who's still in court on habeas corpus because it would be too easy to moot it. All right. So he found out he was going to get shipped back to Allenwood. He was terrified. He did not want to go back to the scene of the crime, so to speak. Although this is not a crime according to most Americans who want it that way. So I helped him get him into the Life Connections program, LCP, just so that he could have an excuse to stay here. And that involved a lot of weird stuff, I might say in another video, but basically it wasn't terribly easy to do. But it worked, and he doesn't have to go back to Allenwood. He's a splendid artist. I'm still in communication with him, and I'm asking him to make me a t-shirt design for a judge on the toilet wiping with the Constitution, which is about as literally true as you can get. All right, another guy I'll call Prison Help. Now, I didn't do papers for him, but I did a lot of legal stuff with him, and I've seen all his papers too. This is even more egregious. So, the feds originally went after him. Well, maybe this was state, but I think it was fed, on the idea that he was chatting with somebody who was 14 years old. Okay, so they, banged into his house, took all his stuff. Fortunately, Prison Help had quite a lot of money and had a backup server in the closet. Now, everybody, all the defense attorneys and stuff, told him he had to plead guilty. He had to plead guilty. They were dead to rights. Had to plead guilty. But fortunately, they didn't confiscate his server, which backed up all the conversations and showed quite clearly that whoever it was who was trying to entrap him, probably a big hairy detective, said that she was not 14, but rather 24. So he wasn't convicted. Justice was served. Yay, America! So then they went after him again. They got his computer, and there were 3 images that were completely blank. But the government stated that, well, before they magically became blank, they were child pornography. Now, again, all the lawyers told him that he had to plead guilty. He had to plead guilty. And said, I'm not going to do it. He fired the lawyers. He said he was going to defend himself, and he's certainly intelligent enough to do that. He submitted his witness list. The judge says, no, I'm not going to let you call any witnesses, period. So he couldn't defend himself. He told me that he spent the trial reading comic books because that was the only thing to do. So they convicted them. They convicted him. And I worked with him, and we worked together a lot. And I forgot to say something about Varian. The prosecutor only wanted 15 years. But the judge kind of arbitrarily decided that he should be put in prison for 29 years. Part of his 2241 involved the idea, well, it was done after 1 year after he had 1 year after a court ruling that opened the way, not for him, but for somebody else. Okay, but that's pretty much the only way you can get a second or subsequent habeas corpus in federal court. Thank you, Little Willie Clinton, is to have the law change for somebody else. So this is pretty arbitrary, I think. I still write him. I hope he doesn't die in prison. I hope he gets a couple of years outside of prison, but he's grossly overweight, had a gastric bypass. They're not giving him the proper diet that is medically prescribed for him. Fabulous guy. Fantastic artist. But sex offense. All right. So I think I've said enough about how sex offenses work. But now actually, I think I have to say, how do the feds and the government get away with this? It's very easy. You see, when a term is undefined, then the courts interpret it in terms of the ordinary meaning of words. Now, that's usually pretty good. However, when it's defined otherwise, or either by the legislature or by the courts, then it can mean anything Humpty Dumpty wants it to mean. Now, the courts already did this with a lot of words you probably think you know what they mean. In Alford, they redefined guilty not to have anything to do with guilt. In Herrera, they redefined innocent not to have anything to do with innocence. Now, you could read the opinions yourself. Herrera was Sandra Day O'Connor. Oh, gee, remember back in the 1980s when feminists were saying that women were so wonderful and all we had to do is get them in power and it would be a kinder, gentler world? Well, what we got was Sandra Day O'Connor, and that is what happened. So let's move on to my personal experience with supervised release. Here's how supervised release went. A long, long time ago, the federal courts worked approximately like state courts. If you were guilty, if you were convicted, you could go to prison. Or you could not go to prison and instead have something called probation. And in probation, you'd have to report to somebody and you'd be monitored and you'd have to stay away from certain things. And if you didn't, you could be sent to prison and serve out the rest of your sentence there. Or serve your sentence there. You would be sent to prison. On the other hand, there was parole. And that meant that you would be imprisoned, but you might be released, either after a specified amount of time, or you could apply for it. And then you'd be under a condition that was very much like probation. You'd have certain conditions you'd have to follow. And then if you didn't do them, you'd go back to prison, but only until the end of your sentence. Now, in 1984, nice year, huh? And 1985, the federal government completely got rid of probation and parole. I knew a guy in prison called Preacher. Very nice guy, very soft-spoken, very gentle, very decent person who had been convicted before they did this. And so he was still fighting the parole board. He eventually died because he was exposed to chemicals when he worked at Unicor printing comic books for sale on the open market. How does the federal government do that? Well, that was an Obama idea. Obama first made it illegal to import forced labor products, and then made it legal to force labor products in the U.S. All right, so back to supervised release. But in any event, they had all of these probation officers lying around. And so they had to give them jobs or something. And so what they did is they replaced it with supervised release. And the way this works is that you serve your entire sentence and then you are released. But then you are subject to what's called supervised release. In many cases, including mine, completely arbitrarily for the rest of your life. And if during that time you do anything that your supervised release officer, which they still call probation officers for the purpose of confusing people, and it works splendidly, anything that they don't like, they can send you back to prison for however long, really. Now, you do get a hearing and a lawyer, but there's no presumption of innocence or anything, and there's no requirement at all that anything you have to do with would be illegal. Now, I was very frightened about this because I had a couple of friends who had been returned to prison and told them told me what their supervised release officers, I refuse to say the P word here because it's a lie, told them not to do. One was told that he could not even address Prison Families Anonymous, which is where his wife went to support, and he wasn't allowed to do anything that was even remotely related to activism. So yes, Virginia, I am risking re-imprisonment for making this video for a bunch of Americans who don't care about their own civil rights. Now, my probation officer seems to be a lot more reasonable than that, and so probably he won't do it. And of course, I've got court, and I actually have a year to file a 2255 challenging the supervised release. But unfortunately, this goes back to the same judge who sentenced me, who was also the same judge who denied my first 2255 on what, if anybody other than a judge would do it, everybody would call a complete lie, who, by the way, is also the same judge who heard the case when my prosecutor was fired, almost certainly due to some emails, which almost certainly had something to do with my case, and she sued, claiming that she was discriminated against for being pregnant, and also she reported that she was being treated for a mental disorder. How that worked out in the case, I don't know. But the same judge who denied me by dismissing my case any discovery to get those emails also sealed those emails in that case, so I'll never be able to find out what it said and why she was fired, even if it's about me. And that's the way, Americans like it, Anyway, I can file this thing that goes back to her. How many people want to bet what it is that my chances are? How many people want to lay odds for me? All right, so now we'll go to the registry, the sex offender registry, which is a slightly longer story. But it goes, and it's very complex, and it goes a little bit like this. A while back, a boy named Adam Walsh was killed. He was decapitated. There was no evidence at all that there was any sexual abuse. And so the American people, the noble American people in New Perfect America, and all the politicians, called for a registry not of people who decapitate children, because that's just good, clean American fun, but sex offenders. And of course you think you know what a sex offender is. It's rape or something horrible like this. So there was also a push for, there were challenges to this. In, I believe it was 2005, the Supreme Court in Smith v. Doe's declared that constitutional because it was a question. But it was a very narrow victory, and there were two interesting things about it. The first interesting thing was that they claimed that the recidivism rate for sex offenses overall was 60%. This is completely bogus. It's about 2 to 3%. And most of these are actual contact offenders. Almost never does somebody who sees something bad on the internet ever touch a child. So, anyway, they got this from a Psychology Today article, and it was done by a completely uncredentialed guy who had a special program, and he just claimed it and they bought it. Well, in prison, I found a copy of some congressional testimony by Richard Wohlert, who is at the University of Vancouver, and so I wrote him. Almost nobody ever writes prisoners back. I'm just mentioning the very, very few who did. Anyway, he wrote me back with his book chapter, which gave a much better description of the science, and he wrote on it, wouldn't want you to get below the 0.05, and if you're a good enough statistician to recognize that joke, kudos to you. So, note that the case, Smith v. Does, involved an actual criminal who had done something physically bad to a child, and not just seen something on a screen. And so they, even so that is true, they had to stretch it to make it constitutional. And Alaska's law, which is what this was about, did not impose any restrictions on movement. You just had to register, and the cops knew where to find you. And so they argued, well, this is no bigger a deal than registering to vote or something like that, so we'll allow it, but only because it doesn't require any restrictions on movement. This will become important later. So there was a push for a national sex offender registry by the federal government. Now, this would be too unconstitutional even for them, but fortunately, there was a way of getting around it. It was a very similar trick to the Marijuana Tax Act of 1937, which was, of course, to protect us from all of these rapist Mexicans crossing the border. Sound familiar? And what they did is that in the 90s, during the Clinton-Biden crackdown on crime thing, they started some federal programs to assist local cops and state cops and things like that. And these programs had two advantages for the cops. First, the cops could team up with the federal government and thus evade all civil forfeiture, which is where the cops just take your money and your stuff for no reason without having to give a reason, and if you want it back, you have to sue them. And many, many videos, some by the excellent Steve Leto on here about that, so we know all about that. That was something Joe Biden loved. And so George W. Bush, for all his faults, cut these programs way, way back. But as soon as Obama got into office, they went back up again to the billions of dollars. Now, I'm pretty sure this was Mighty Joe's idea and not Obama's idea. There were certainly a lot of problems with Obama, but most of them were his being completely ineffectual and not actually outright evil, except for something that I might get around to telling you later. And so, what the federal government decided to do is decide to bribe the states. They decided to say that you have to have this sex offender registry and it has to have these properties. And if you don't, we'll cut this one program by 10%. Well, because Biden had increased the cash, that was enough money to get states interested in doing it. At the George W. Bush levels, again, a guy with many faults, it probably wouldn't have been worth the administrative overhead. So essentially, they bribed or blackmailed, if you will, the states into doing this. But it would be way too unconstitutional for them to control these programs. So each state has a lot of freedom. Some of the programs, in fact, Colorado program, was like Alaska's program. It really wasn't. They just published your name, which they justified by saying it's already public information. A lot of the states, including North Carolina, which is where I will probably be for the rest of my life, have lots and lots and lots of restrictions that go way beyond the limits that the Supreme Court said. How do they get away with it? Well, the Supreme Court doesn't care. The Supreme Court only hears the cases it feels like hearing. And this is not because there are so many cases, because in the 1890s, the Supreme Court heard twice as many cases, I'm talking numerical, not percentage, as they did now. But back in the 1890s or thereabouts, the opinions they came up with were masterpieces of clear thought and concise wording. Now they run on and on and on and on and on with political opinions and blah, 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 and nonsense. And they're so hard to understand that fairly regularly, the media have no idea what the opinion said and just make stuff up. So essentially, the federal government is blackmailing it with with this resulting in an awful lot of bad law. Now, Colorado, which was also like Alaska, had a case, and the case involved 3 people challenging the constitutionality. One of them was a guy who was convicted and is a lifetime sex offender for something that he did at the age of 18. So yes, Virginia, if a 13-year-old plays doctor, that is a sex offense, lifetime registration. Now, despite the limited nature of the Colorado, they had a really serious number of problems. It was hard for them to find jobs. People would go around and hound them, yada, yada, yada. So the District of Colorado declared SORNA, which is the national act, and the Colorado state, well, maybe they didn't do it to SORNA, but they did it to their registration system. They declared it unconstitutional. This was fantastic. But the government appealed. It went to the 10th Circuit, which is, Colorado and a bunch of other states. And the 10th Circuit reversed the decision. So I think I'm going to take this time to point out, have you ever heard of Paul W. Tibbets? Well, he is the guy who dropped the first atomic bomb on Japan. Probably, I'm guessing, the highest security position in the United States ever. Well, when they were grilling him, they said, have you ever been arrested? And he said, yes, when I was a teenager, I was arrested for doing something with another girl in the backseat of a car. Now, they didn't think much of it. They just wanted to check to see if he was honest. But nowadays, he would have been a sex offender for life. And he would never have been allowed to do anything. And I wrote Harvey about this, and he fully agrees. So that is what your federal government is doing. So we have 13-year-olds as lifetime sex offenders for whatever it is you think a 13-year-old could do. And you probably think it's incredibly heinous, but, you know, if I haven't persuaded you that these laws are overbroad and used wrongfully by now, I'm not going to try. It's not worth the effort. If you want to believe America is new perfect, I don't want to spoil your parade. I don't want to make you unhappy. So be happy. Have a nice, organic, GMO-free almond milk latte. That's what life's about. So now to my case. So North Carolina is very restrictive. And being on the sex offender registry would cause me a lot of problems. I wouldn't be able to go to the only downtown shelter that would take me because and not die on the streets as an insulin-dependent diabetic because of its location. I wouldn't be allowed to go to Chabad to get stuff for Hanukkah. I wouldn't be allowed to go to the distribution points for Jewish Family Services, where I get a lot of food. I wouldn't even be allowed to go to the counselor I was ordered to see. And let me make a note. I should talk about that at the end because it's part of the story. Blah, blah, blah. So that was very frightening to me, and I tried to, and terrifying me. Oh yeah, I wouldn't be eligible for pretty much any re-entry program. Murders are okay. Mass murders, all right. But anybody who is any sort of sex offender, no siree, Bob, ever go die on the streets. And those are my conditions. All right, so within 72 hours of release, I had to go register at the sheriff's department. I went down to the sheriff's department. They treated me very pleasantly. They were happy to see me. They treated me as if I were a human being, right? It seems fairly obvious to me that they think the registry is a joke, which it is. It has not prevented, from the evidence, a single crime, and it impairs people's lives. It makes it in fact, probably, because if you prevent prisoners from any meaningful re-entry, and they can do crimes, and they have to do crimes to stay alive, they sure will. But that's the way, Americans like it, Anyway, so I was talking to them, and he said, well, blah, 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 and I said, well, this is a federal conviction. I said, oh, we don't do anything about federal. We don't deal with federal. And what? Well, it turns out that they have utter contempt for the federal government, which you should too, by the way. Contempt for the federal government is not just for Republicans anymore. In fact, they're the ones who are doing a lot of this bad stuff. And so they told me that I could petition the court not to be put on the registry. Great. They told me, and it was on the form, that I had 30 days to apply. And this is where it gets really, really interesting. Because I had my supervised release officer who seems to be pretty okay and pretty reasonable, and probably I won't be restricted too much in the future, though it will take time. And it says, when's your court date? When's your court date? And I said, after I file. He said, you haven't filed yet? No. I have 30 days. Who told you had 30 days? So I gave him the phone number and he called. Well, actually 30 days is right on the petition and it's right on the law, and in the law. Okay, so at the sheriff's department, they had suggested, well, you could fill it out and file it in the court right over there. Just get it done today. I said, no, I'm not going to do this. I am going to do the whole full Monty on this, and I'm going to take 30 days to do it, and I'm going to research it. Now, here is the petition. It's just one page, so that's not really anything. But I knew from my previous work that I can legally file a supplemental brief in support of any petition. That's okay under North Carolina law. It's pretty much something that's okay anywhere because, hey, you're supposed to have a right to present your stuff to the court. But the point is that apparently my supervised release officer had never heard of anybody doing that. And so maybe I'm the first, or at least it's very unusual to do it. So I typed up my supplemental brief, which is right here. Fortunately, I can access a computer, not at home, which is why this is so primitive. But I can access it at NC Works, which is the job getting place, and they have Century typeface, which is required by the Supreme Court for petitions for certiorari and original habeas corpus, and which have to be done in booklet form. And you have to give them 40 copies, which now I can do. I couldn't do that in prison. I couldn't even produce the exhibits I needed, but I'll get to that. So here's the supplemental brief. It's 7 pages long. Not too long. And so, as I always do, because I was really never told what I was supposed to have done. I pleaded guilty. Well, first of all, you try being not allowed to sleep for 3.5 weeks. But I still had a little bit of brain left, maybe a half cylinder, and I decided I was going to plead guilty if I was able to find out what the image I had supposed to have downloaded was, and if I recognized it. I had to snatch a piece of paper away from my my public defender, my pubic offender, at the arraignment and rapidly read it, and I barely remembered it. It's not child pornography, folks. It's not pornography. There's no nudity. There's nothing at all sexual about it. But I only knew the common meaning of the word guilty. I didn't know about Alford because in North Carolina jails, you don't get to use any legal resources. You don't get to look up any laws. You don't get to look up any case law, any judicial decisions. So, on page 2 is a description of the image. The image depicts a girl around puberty. She is wearing a white spotted bikini and has a neutral or even bored expression. The bikini is somewhat large and not revealing. 2 thick white ropes lead down from the top of the frame to a horizontal bar about 8 to 10 inches long. Her hands are extended upward behind the bar. Now, this is actually a more accurate description than the one I snatched away from my pubic offender, because that said that the ropes went up to the ceiling, but the frame cuts it off. So you can't tell whether it goes to the ceiling. Now, there is nothing at all sexual about this image, nothing sexually suggestive about it. I thought when I saw it, and I downloaded a lot of images for clip art, so I don't know where I got it from. I thought, this was a girl dressed perfectly appropriately for Florida, reaching up to an improvised trapeze. I didn't think anything of it If you saw it, you wouldn't either. I have no idea where it came from. I just knew that I had seen it. So I pleaded guilty because I had decided that wrongfully that guilty meant that you'd done something. Doesn't that mean that? No, because judges can define words however they like, and if you don't know that. And my attorney was, my public offender, excuse me, was completely unhelpful because he said, you're going to be required to plead guilty to an image. And I said, well, what was the image? He said, why do you want to know? I mean, how do you answer something like that? So I said, well, I'm curious. And he said, oh, he's curious, isn't he? That was, by the way, Joseph Lanny Ross II of the, the Raleigh Federal Public Defender's Office. All right, so now this is the law as applied to me. It's obviously wrongfully applied, or it's unconstitutional for overbreadth. But here's my argument. Because I noticed on the back, the judge has to check a box, and one of the boxes saying, the petitioner's out-of-state or federal conviction set out above is not substantially similar to a North Carolina